How does work for hire impact freelance project copyright? Imagine creating a piece of art, a website, or a video, then discovering you no longer own it. That's what work for hire can do to your rights. It's a tricky part of copyright law that can cause big issues if not understood properly. When you hire a freelancer or work as one, knowing how work for hire affects copyright is essential to avoid costly legal mistakes. Under U.S. copyright law, the usual rule is simple. The person who creates a work owns the copyright. But work for hire changes that. If a work qualifies as made for hire, the employer or client automatically becomes the legal owner of the copyright from the moment it's created. This means the creator, whether a freelancer or employee, loses all rights unless there's a clear agreement stating otherwise. There are two main situations where work for hire applies. First, if an employee creates work as part of their job, the employer owns the copyright without needing a written agreement. Second, if a business commissions work from a freelancer, both must sign a written contract explicitly stating the work is made for hire. Without this, the freelancer retains the copyright, even if they were paid for the project. Many freelancers make the mistake of assuming they keep rights to their work after signing a contract. But if there's no written work for hire agreement, they usually do own the copyright. Conversely, some freelancers sign contracts with work for hire clauses without realizing they are giving up all rights permanently. This means they cannot reuse the work, include it in their portfolio, or license it to others later. Businesses often believe that paying a freelancer automatically transfers copyright ownership. That's false. Without a signed agreement that states the work is made for hire, the freelancer still owns the copyright. The company's payment only covers the work's delivery, not the rights. This can lead to disputes if the client starts using the work beyond what was agreed. A common misconception is that work for hire applies to all types of work, like software or creative projects. But the law is specific. For commissioned work to be considered made for hire, it must fall into certain categories, such as contributions to a collective work, parts of motion pictures, or translations. For example, a custom website or marketing campaign might not qualify unless there's a clear written agreement. Relying on assumptions here can cause legal trouble. For work created by employees, it's automatic that work made within their scope of employment is work for hire. But what counts as within scope can be blurry. If an employee creates something outside their job duties or on their own time, they might keep the rights. For example, a graphic designer hired to create logos owns those logos, but if they design artwork on their own time, they retain rights. It's important to remember that work for hire only covers copyrightable works. It does not transfer rights for patents, trademarks, or trade secrets. If a freelancer invents something patentable or develops a secret process, separate agreements are needed. To avoid these issues, always use a detailed written contract when hiring freelancers. Clearly state whether the work is made for hire or if rights are being assigned. If the work doesn't qualify as made for hire, include an assignment clause to transfer copyright rights. Freelancers should carefully review contracts before signing, making sure they understand what rights they are giving up. If they want to keep some rights, they need to negotiate those terms upfront. Both parties should keep records of all agreements in writing. Verbal promises about copyright ownership are not enforceable. Having everything documented helps prevent disputes later on. Remember, understanding how work for hire impacts copyright is key to protecting your rights and avoiding costly legal errors in any freelance project.